Hi friends, I am your friend advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, in this video, we would like to discuss that what happens if the plaintiff or one of the plaintiff dies and his right to sue of the legal heir survives and how to bring them on record, what is the provisions of Order 22 Rule 3 of the Code of Civil Procedure, is there any period of limitation for bringing the legal heirs of the deceased plaintiff on record on the court. Sir, we would like to discuss and I would like to read Order 22 Rule 3 of the Code of Civil Procedure. Before I proceed further my video, I would like to request that if you have not subscribed my channel, please subscribe my channel, and if you like my videos, kindly like and share my videos. I would like to read Order 22 Rule 3 of the Code of Civil Procedure, wherein the procedure has been provided for bringing the legal heirs of the plaintiff on record of the court. Order 22 Rule 3 says, procedure in case death of one of the several plaintiffs or of sole plaintiff, where one of two or more plaintiff dies and the right to sue does not survive to the surviving plaintiff or plaintiffs alone, or a sole plaintiff or sole surviving plaintiff dies and the right to sue survive, the court on an application made in that behalf shall cause the legal representative of the deceased plaintiff to be made a party and shall proceed with the suit. Supposingly, the legal heirs are there, but they does not move any application. So how the court will proceed further and the suit will stand abate automatically. But the meaning of Order 22 Rule 3 subclause 1 is if the right to sue survive. That is very important. You should understand that a plaintiff dies during the pendency of a trial and the legal heir's right to sue survives against the defendant or against the opposite party, then they should move an application and the court will allow the application if the court finds that the right to sue survives. Then what is Order 22 Rule 3 subclause 2? I would like to read. Where within the time limited by law no application is made under subrule 1, the suit shall abate so far as the deceased plaintiff is concerned, and on the application of the defendant, the court may award to him the cost which he may have incurred in defending the suit to be recovered from the estate of the deceased plaintiff. What does it mean? It says about the period of limitation. It says that if no application is made within a period of limitation. Now the question is, what is the period of limitation? So it is very relevant and important. The period of limitation is 90 days for bringing the legal heirs on record. Supposingly, father dies and son does not know about the proceedings, so he should contact to his advocate and he should file an application through his advocate within a period of 90 days. What happens if he does not move an application within a period of 90 days? Then his suit automatically abate. In that case, he has to file two other applications. Along with Order 22 Rule 3 application, he has to move an application for condonation of delay and explain the reason that why he could not file that application within a period of 90 days. He has also filed an application under Order 22 Rule 9 of the Code of Civil Procedure for setting aside the abatement because the suit stands abate automatically within a period of 90 days. Now the question arises how to draft that application. So while drafting the application, first you have to mention the name of the court, then the case number, then name of the parties, and you have to mention deceased after the title of the plaintiff. Then you have to state title or application under Order 22 Rule 3 of the Code of Civil Procedure along with or read with Section 151 of the Code of Civil Procedure. Then you have to start pleadings of the application. Say that the plaintiff has been died on such and such date and I am or we are the legal heirs of the plaintiff. State the relationship with the plaintiff. Also state the date of death of the plaintiff. Then you have to mention the right to sue survive because it may be a reason that it's an immovable property or other valuable rights. So you have to specifically state in your application that right to sue survives, and so we should be implemented as a necessary party in place of the deceased plaintiff in the suit. And if we will not implemented as the party, our valuable rights will be affected. Then now important question is what documents you should file. and what relief you should seek. So you should seek the relief that we should be impleaded in place of the deceased plaintiff in the suit. And what documents you are required to file. So documents you have to file is the death certificate number 1. Then if you have the ration card, then you have also filed the ration card, and you also file other property related document, and you should also file the amended cause title that now we are there in place of the plaintiff, and the amended cause title filed along with the application may be taken on record. Now the question is, what happens if the surviving legal heirs does not move an application within a period of 90 days? Then the suit states abated automatically. It's very relevant and important. What happens many times that the legal heirs does not know that the proceedings of suit is going on, or they does not know that whom we should we contact within a period of 90 days. So you should learn that ignorance of law is no excuse, and suit stands abated within a period of 90 days after the death of the plaintiff. So you have to be very careful for the period of limitation, and if you does not file an application, then after 90 days you have to file an application for condonation of delay. You have to explain the delay, and you also file an application under Order 22 Rule 9. Now the question arises that what are the important citations of the Honorable Supreme Court with this regard. So I would like to discuss here 4 very relevant and important citations, and I would also like to read the findings of the Honorable Supreme Court. The first case is decided on 4th of July 2011. The title is Mangu versus Surendra Singh, and I would like to read what are the findings of the Honorable Supreme Court. That is, when the sole plaintiff dies and the right to sue survive on an application made in that behalf by the legal representative, if the court holds that the right to sue does not survive on the death of the plaintiff, the suit will abate under Rule 1 of Order 22 of the Court. It means that if the court finds that right to sue does not survive, so the important aspect is that upon the surviving legal heirs, the right to sue must be survived. Next is, even where the right to sue survives, if no application is made for making the legal representative a party to the suit within the time limited by law, the suit abates as per Rule 3, Sub-Rule 2 of the Order 22 of the Court. So the period of limitation, as we have discussed, is very important. And thereafter, what Supreme Court held is, where a suit abates or where the suit is dismissed, any person claiming to be the legal representative of the dismissed plaintiff may file for setting aside the abatement. So all the important and relevant aspects has been discussed, and principles has been laid down by the Honorable Supreme Court in this judgment. And the next and very important judgment is Supreme Court is Shanti Devi versus Koshala Devi, and it has been decided on 18th of September 2015. And what happened in this case is, the legal heir has filed an application after a period of 11 years. The first appellate court and high court has allowed that application, but the Honorable Supreme Court says that it is too much delayed, period of 11 years, so the suit stands abated and abatement cannot be set aside. The next judgment of the Honorable Supreme Court is Balwant Singh versus Jagdish Singh, and it has been decided on 8th of July 2010. What happened in this case is, what the Supreme Court held is that application for condonation of delay should show the sufficient cause if application for setting aside abatement filed along with application of Order 22 Rule 3 c.p.c. And if delay is not explained, the delay cannot be condoned. What happens that many times, as we have discussed in earlier case, that after a period of 11 years the application has been made. So in this case, the Supreme Court has categorically held that the delay should be explained, and if it is not explained, then the suit will stand abated automatically. And the last citation we would like to discuss is Honorable Supreme Court decided on 18th of November 1996, and the title is Rama versus Sata. And what decided is, the delay has been condoned and the abatement has been set aside in view of the fact that the appellant is poor villager and does not properly advised by the council. In this case, the appellant was the poor villager and he has not properly advised. So the Supreme Court held that since he does not know the legal proceedings, the abatement should be set aside. So in this video, we have discussed that how the legal heirs of the deceased plaintiff can be taken on record under provision of Order 22 Rule 3 of the Code of Civil Procedure. Thank you so much, friends.